Okay. Shiva, could you take roll?
Commissioner Adaro,
Here.
Commissioner Kasher,
Here.
Commissioner Wasserman,
Here.
Commissioner Wynn,
Here.
Chair Remke.
Here. Good morning, everybody. We're going to go ahead and get started right away. But first, is there any public comment for an item not on the agenda?
Yes, good morning.
Good morning.
I'm here this morning to say goodbye, as my term as the chair of the FPPC committee is expiring next month. For the last 6 years, it's been my pleasure working and privilege to work with the commissioners and your staff in our common mission to enhance understanding of and compliance with the Political Reform Act among the hundreds of public officials that we counsel as city attorneys. I'd like to thank Chair Remke for overseeing the completion of the Comprehensive Regulation Clarification Project initiated by former Chair Ann Ravel, and for initiating a similar effort to improve the provisions of the Act as they appear in the Government Code. I'd also like to thank Chair Remke and past and current commissioners for your patience with and thoughtful consideration of the recommendations and suggestions that I brought forward from our committee. And finally, I'd like to thank the members of your staff, and in particular, many members of the legal division with whom I've worked, including Hyla Wagner, current general counsel, her predecessors, Zach Morazzini and Scott Halloran, assistant general counsel, John Wallace, and senior counsel, Brian Lau, and retired senior counsel, Bill Lenkite. It was always a pleasure working with commission staff, and on my own behalf, I appreciate their many years of dedicated service to the people of the state. Thank you.
Thank you, and thank you for your commitment and dedication and appearing here and often giving us good thoughts and comments to consider.
Yeah.
Commissioner Wynn?
I just want to join with Commissioner Remke, Chair Remke, to thank you very much for your constant input in our conversations. The debate was always improved by your input, so thank you very much, and I wish you well in your next endeavor.
Thank you.
Commissioner Kasher?
Thank you for your contributions to the commission, and I know that the work that you do for the league is challenging and that you're trying to shepherd all of the interests of all these various cities. So thanks for doing that and helping us in our policy making here. And I've also had the opportunity to see you brief the league at league conferences, and you've always done a great job of that, keeping them informed. So your contributions will be missed, but we appreciate all that you've done for the commission.
Thank you.
Thank you. Are there any other public comments? Okay, then we'll go to approval of the commission meetings, approval of the March 2016 commission hearing minutes. Do the commissioners have any comments, questions, or corrections? Is there a motion?
I move approval of the minutes.
Second.
Commissioner Adaro,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, we will go to the enforcement consent calendar, and I'll start by noting that item 22 has been pulled at the request of the enforcement division and the Chief West. Good morning.
Good morning. Yes, it has been pulled. New information has come in regarding the qualifications for Streamline. So we wanted to look at that before we present it to you.
Okay. So other than that, the remaining, do the commissioners have an item they would like to pull because they are recusing themselves? Sure, let's just get through the, if there's anything to pull off the list.
I just want to say that all the commissioners, as well as you, Chair, received a letter on 22 that I understand everything is now off calendar on 22. I think we should just briefly address the fact that we received it, and we can do it off the calendar, but just,
It's been posted, so it is a public comment, part of the record. But we're just saying we're not addressing the issue because it's no longer on it. But that letter, to the extent we put the exact same stipulation back up, will go back up when it comes up.
Okay.
Okay.
Thank you.
So if there are no items that need to be pulled from the consent, questions or comments regarding the consent calendar? Commissioner Wynn?
Yeah, thank you very much. And thanks, Ms. West, for your hard work on this. I just would love us to talk a little bit about item number 4. And I'm not suggesting that we pull it off the consent calendar, but there have been questions raised about the adequacy of the penalty.
So this
And
is the Gregory Cox. I just
Yes.
want to thank you.
Yeah, sorry. Yes, I should have said that myself. So yeah, if we could just walk through why you're suggesting, and there has been a stipulation entered into on a $3,000 fine instead of maybe a higher fine.
And then again, for the record, I believe we received about 4 comment emails. Is that correct? Yeah. And they're all going to be posted online to the extent you haven't seen them yet. Okay. Thank you.
Certainly, and most of the comment emails are regarding the fine amount and comments Mr. Cox has made to the press. And basically, for this case, as for all cases, we look to prior cases and how we address those and the criteria that we post in the exhibit to say what we consider for a fine. So when we go through those, we do the seriousness of the violation. And this is a discussion that we've had previously about conflicts, that you really don't get a conflicts fine below $2,500 because that's kind of our baseline. And because of the seriousness of having a conflict while you're in office. And then the other factors, and these are all on page 3 of your exhibit, and they're in every exhibit that we present to you because they're in our regulation. And the second factor was the presence or absence of the intention to conceal, deceive, or mislead. And we always look for that. And in this case, it was a self-reporting case. And again, in discussions we've had in the past, self-reporting is something that we do take into consideration as a factor.
Can I jump in on that?
Sure.
Because I know that self-reporting is an issue we do talk about a lot. And I think one of the comment letters mentioned this, and I would tend to agree. It's hard to call some of these conflicts of interest cases self-reporting. The different argument is whether it was inadvertent to leave it off or not address it at the time of the vote. But once you realize you have an interest and you have to report it on your Form 700, you in fact are exposing yourself to the violation. So the self-reporting to me is not as strong in these cases.
Certainly, and that's why we compared it to the Wong Martin Newsom, where the self-reporting would have been a lot less prevalent for us. It would be harder for us to find and detect without the self-reporting. So in this, where the interest would have been on the Form 700 in just a couple months, the self-reporting was taken into consideration, but not given as much weight as it was in previous cases. So it's like I say, it's one of the factors, but it's not the factor that we look at. So then we go on and we look at whether the violation was deliberate, negligent, or inadvertent. And that's where it gets into more of the intentionally deceiving. Is it disclosed? Is it not disclosed? Is it something that was known and they acted on it on purpose? And in contrast to the other case that's on the agenda, where the interest of Okonkwo was more prevalent. It was her own leasing of her own property to herself through the use of her position. So we look more of the factors in the cases, the other facts of other cases to guide us in what the factors weight should be.
I'm just going to jump in again because I guess the problem with this case is part of it is the underlying issue of SeaWorld and it being such a big issue that's discussed or has been discussed in the press just so prevalently. And it's almost there's this assumption that how could he not have known his wife was buying stock, or how could she not have known this would create a conflict? So, but that's only an assumption at this point. And I guess you're telling us that there was no actual evidence of his knowledge regarding what was done or not done.
Correct. And that's what we take into consideration. So we look at what the actual evidence shows us. And the evidence in this case did not show us that he had knowledge that his wife had purchased the stock. And this is similar to the other case. And like I said, we use the other cases as the guide that the commission has approved, where it's similar to the other case that it's the actions of a third party in acquiring an interest that caused the conflict, not the actions of the public official themselves, which also shows if you don't get the evidence to show that it was intentionally done, a deliberate violation of the act, then these are all factors that you're looking at. And so then you look at the next factor, which is, did they file corrective amendments voluntarily to provide full disclosure, which happened in this case, and whether they have a prior record of violations, which they do not. So these are the factors that we take in consideration in every every case, whether it be a conflicts campaign or whatever, and then we look at the other cases as priors, so to compare. So we looked at the Wong Martin Newson case, which was a self-reporter case, and we looked at the case that's on the agenda at the same time, Okonkwo, to make sure that we're applying these factors equally to every single person. And so, subject matter aside, these are how we come to the conclusion of what the proper fine amount is.
And I think that addresses the issue of the public comments, which, I think are appropriate. We take into consideration, but for them, it's the passion of the subject matter, which we do have to put aside. Now, I guess it would be a different conclusion had his vote actually helped determine the outcome.
Correct. Some of the factors we look at in conflicts cases is, was your vote the deciding factor? Were you the swing vote that you were the cause of something to happen or occur? Were you the cause of your own benefit? And so these are the things that we look into in the subject specific cases for conflicts. And so we look into the amount of the benefit, and this all kind of goes back to the factors. We're looking for intentional behavior, and we're looking for benefit, and we're looking for public harm, because generally in every single case, it's the public harm that we're looking for.
Commissioner Odero, did you have a question?
I think probably just a comment. I also am not swayed by the self-reporting. I think it could be a very cleverly planned and executed situation where I violate and then I report and then I'm okay. So I don't put a lot of weight into the self-reporting. The lack of knowledge here, I'm not sure. I think he had more of a duty to stay on top of things. The amount of benefit, on the other hand, I think was like $1,000 or something.
Correct.
Not to minimize $1,000, but that one swayed me a little bit toward the other side. I am interested in what facts we have regarding how many other votes there were and how they fell.
This was 2 votes and occurring at the same time. And the first vote was on his own motion, which failed 11-1, his vote being the one. And then I believe he withdrew his motion at that point, and they put the new motion forward, which then he voted with the group 12-0.
I love commissions, in particular the Coastal Commission, because there are at least 2 bills pending right now regarding the Coastal Commission and the process and concerns that are raised, whether or not due process is being followed and whether or not there are conflicts occurring and improper influence and the like. And I think that this case, I just like to highlight, because I think it shows that the system does work and that the Coastal Commission, like all state agencies and commissions, are subject to plenty of regulations, including the conflicts of interest, having to file Form 700s, showing what their interests are. So they're subject to the gift limits, 1090 in the contract laws, 84308 as far as accepting contributions, because he was a supervisor, had he accepted a contribution, that could have been a disqualification. And of course, anyone who lobbies, Coastal Commission members are also subject to lobbying registration. So I think that this shows that people need to take these kind of cases and the rules that already are subject, the Coastal Commission is subject to, in mind when we're looking at legislation, which we may talk about later.
And I would just like to point out that any of the commenters that provided information for the commission to consider are always welcome to file complaints, because we would love to hear from them if they see people that aren't registered or behavior that needs to be reported. Our doors open.
Okay.
I have a question about that. What is the line between a comment letter and a complaint? At what point does a comment letter say enough for you to consider it a complaint?
It's a fine line, because anything that sparks an interest to where we need to look into it. But then again, it's a resource issue, because we have 30 employees for the entire state. So it is a fine line between the two. But obviously, if there's someone that files a comment letter that says something of substance, we will follow up with them. Whether or not we open a case remains to be seen.
Okay, any more questions on this one? Okay, any more questions from the commissioners or comments on any of the other items on consent?
Yes, I'd like to talk about number 3, actually, since we're on the topic. I think it's a similar discussion about the mitigation aspect, because as you indicated, the facts here are pretty solid direct benefit, direct contracting, and some maneuvering around to shift the leases to a corporate entity then owned by the mother, etc. And then we come to a mitigation factors. Could you just run over those again and how it gets to, instead of like a 20,000 down to a 16,000? I mean, in both of these, I think some of the question for the public really is there are limits to what we can do. And some of the things that comment letters come in with are sort of, can you do this? Why don't you do this? And we can't.
Mhm.
But my question is, how did we end up at 16 instead of 20?
Generally, Galena West Enforcement Chief, generally on Kendra Okonkwo's case, the mitigation was her lack of knowledge of the rules, and that she had some reassurance from the charter school system that she worked in that she was doing things fine, and there was a board approving these leases and actions. And so when we were taking into consideration her actions, even though a lot of them appear to be very self-motivated, her mitigating evidence was that the board had to still approve the contracts. She left the room anytime they considered the contracts for the leases, and that some of these requirements, the ADA requirements in particular, were requirements to keep the school open that had to occur quickly, and she hadn't really considered the ramifications according to her. And in a lot of ways that it was believable, because once it was brought to their attention, they voided the contracts and they stopped all of the behavior. And so it was just, unfortunately for her, the pattern, that one of the factors was, is this a single instance or a pattern, goes against her to where she has to receive a higher fine, because this is a pattern of behavior and there is quite a substantial benefit. But then the other factors with her knowledge and her priors and not having any, and also having this board somewhat rubber stamp what she was doing, is in mitigation for her, because she did have an outside entity almost reviewing these leases and saying, okay, go ahead. So we take all of that in consideration and balance it out to, okay, maybe this isn't a max fine to where she was intentionally doing this and really did see herself as some sort of benefactress of the charter schools to keep it open and functioning with these ADA requirements and making it all happen. So those
that
are the
gives
things
me
we
a
were
couple
looking
of,
at.
sorry.
Go ahead.
Okay, that gives me a couple of follow-up questions.
Sure.
If she received guidance from charter schools, some sort of entity that directed her that this course of action was going to be okay, then at the very least, I would say that's an opportunity for education. Because if she went to a resource and they steered her wrong, regardless of her culpability or often the willingness of a participant to want to hear, hey, that's a great answer, I'll go with that. I think that'd be a great thing to sort of refer over for educational purposes to get back to them, so that door closes.
Let me address that real quick.
Sure.
Charter schools are a ongoing project for us. We deal with a lot of charter schools in a lot of different ways, and we reach out to them constantly and refer them to the education division, because there's some confusion, as there's even a recent advice letter regarding charter schools, because they were unclear if they were even able to be applicable to the act and if they fall under it. And so it was a basic question of, we're a charter school, the act doesn't even apply to us. So it really goes down to that basic level of misunderstanding that we're trying to educate about. And we've been working with Highland Legal Division in order to really promote that and encouraging people to write in. And because some of them had believed that they didn't even have to file codes.
And although it isn't necessarily our area, just because we're sort of in the mix on this, it's a good time to remind folks that the oversight responsibilities and judgment responsibilities of any board, commission, committee, board of directors, etc. Did they have an independent committee reviewing these transactions? I'm assuming not.
No.
Yeah. Okay. Yeah, I was just trying to get into this information to decide if I wanted to ask to have it pulled to actually vote on, because
I understand. Conflict of interest cases are all very fact specific and complicated.
thank you.
Any other questions regarding items on the consent calendar from the commissioners? Any public comment regarding an item on the consent calendar, noting what we already have in the record? Okay, seeing none, is there a motion?
I'll move to approve the consent calendar with the exception of number 22, which was removed.
Thank you. So 3 through 27 minus 22. Is there a second?
Second.
Commissioner Adara,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
and Chair Remke.
Yes.
This motion passes.
Okay, thank you. And then next we have item 28, which is regarding assignment of hearing to an ALJ. Again, as always, this is a recommendation from the Chief of Enforcement and Executive Director, and it does not require a vote. But before we submit it for that action, are there any questions or comments from the commissioners for Ms. West? Okay, so with that, that will be submitted and that recommendation will be accepted.
Thank you.
Then we will move to item 29, which is Regulation 18750. Why is that podiums? Is that on?
Oh, we forget that every time. Senior Commission Counsel Brian Lau with me, Trish Meyer, really our in-house expert on code adoption and amendment procedures. I'm here to present the repeal of existing regulations 18750, 750.1.2, and 18752, and the adoption of proposed regulation 18750, consolidating the procedures for the adoption of conflict of interest codes subject to the Commission's approval into a simple single regulation. Under the Political Reform Act, every agency in the state must adopt a conflict of interest code, which designates all positions within the agency that are involved in making or participating in decisions which may affect a financial interest, and specifying the types of interest that each designated position must report when submitting their statements of economic interest. A newly created agency must submit a new code within six months, and amendments for changes in circumstances must be submitted to the code reviewing body within 90 days. Agencies must also review their codes every 2 years. The Commission is a code reviewing body for all state agencies except judicial branch agencies and all local agencies with jurisdictions in more than one county, often called multi-county agencies. In all, the Commission is responsible for approving the codes for approximately 200 state agencies and 600 multi-county agencies. In the light of the number of codes the Commission must review, staff has been identifying ways in which to streamline and simplify the code approval process for both the adopting agency and the Commission. This proposal is the result of those efforts and accomplishes several primary objectives. First, as mentioned, this proposal will simplify and consolidate the existing regulations. If you take an actual examination of the regulations, there are far more similarities than differences between all four of them. And we feel just moving them into a single regulation should reduce the complexity of the regulatory framework. Second, subdivision A1 adds standard code requirements to the procedure, which are not currently identified in the existing regulations, essentially our minimum expectations of any code submitted for approval. Third, this proposal provides a preliminary review of proposed codes and amendments. Over the course of years, the existing regulation kind of sets up a procedure where the agency adopts it first and the Commission looks at it second, which leads to the agency going through a lot of wasted effort in adopting something that we may not ultimately approve. So working with them simultaneously through the years have been beneficial, and it's can drastically reduce the time necessary to review approve the codes. So subdivision A2 codifies this procedure. Fourth, this proposal deletes unnecessary language regarding the Commission's review of the code, which is duplicative of the existing statutory provisions. As a final note, I will point a typo on page, it's proposed 18750, page 6, line 23. It reads, must be transmitted by to the office of, which is obviously an error. The couple words omitted, it should read, must be transmitted by the agencies to the Office of Administrative Law. So we're making that recommendation prior to adoption, prior to consideration. So with this, staff recommends the adoption of the proposed regulation and the repeal of the existing regulations, and I can attempt to answer any questions you may have.
Well, I just want to thank you, Brian, and Trish for all your hard work on this. When I started here, I did not realize the extent of work code reviewing encompasses. It is a huge job and a lot of staff time, and you guys do a great job helping the agencies. And I know that the agencies also can get frustrated in the process and how cumbersome it could become. So I know in addition to these regulation changes, you guys have also been working on fact sheets and checklists to kind of really just streamline this process. I mean, it has to be done, but we need to do it in a smoother, faster way. And I think we're headed in that direction. So thank you for all your hard work and getting us there. Commissioner Wynn?
Well, so Jody didn't know this until she started here, but I didn't know this until I read this agenda. So I just had first of all, I think you've done a nice job really taking the complexity out of it and really, kind of getting it down to a really usable set of regulations. So thank you for that. I just was curious, so how much variation is there kind of jurisdiction to jurisdiction in these conflicts, codes? Do they just try to hew to the, regs, or do they, kind of take liberties with it?
I think it varies quite a bit
Okay.
just between agencies. You have a lot of codes that are rather similar, and then the language that we kind of try to move them to some sort of uniform language. But then you get agencies that can be very gung ho as far as what language they're looking for, and on top of that, you actually have agencies that really will push something like full disclosure when it's not justified just because it's the easier solution, or agencies that are trying to fight full disclosure. So that it just kind of really ranges the entire gamut.
And with the different positions from agency to agency is really the issue, and what their responsibilities are regarding the scope of their disclosure, or they should for each position. So
Right, and for some of the big agencies, it just gets difficult for them to push
wanna
the
name any
code
names?
through to list all the positions. And so, Trish and Ivy Brannaman and Cynthia Jones kind of working with the agencies and just helping them do it. And Brian it's great.
And one thing we've been trying to do too is to get standard language for the agencies. So if you have, for example, your CIO or an IT staff that, maybe is a lower level IT staff, but does do some procurement. So we're trying to get sort of standard language so that we can at least help them when they can identify all the positions. At least we can say, okay, normally we recommend that type of a person is filing, under this disclosure category.
Yeah, it just seems like this will be really helpful. So thank you very much.
yeah, and it's not a sexy or sensational regulation, but it is part of our core function. And so it's one of those things that doesn't get a lot of attention. But as we saw from the discussion on the enforcement agenda today, conflicts and what people have to report is obviously crucial to the whole system. So it's necessary. So thank you. Any other comments?
I just have a question just for my education. What is our what's your process as you're going through this? How much involvement do you have in guiding versus just kind of supporting what they want to do or redirecting what they want to do?
I get the complicated issues typically kind of get referred to legal, where I will address kind of the more difficult codes or the agencies that are refusing to make changes at our suggestions. But I'll let Trish speak to the more typical process.
Trish, Legal Division, hi. For the multi-county agencies, it becomes difficult because they don't meet that often, and working with them, there's high turnover. But there are a group of attorneys that handle a lot of the multi-county agencies. State agencies tend to be difficult because of the high staff turnover within agencies. Usually it's assigned to a person who will work on it for a while, and then that person's reassigned, and we essentially have to start over with another person, another attorney. So that's kind of where the difficulties arise as far as processing the amendments.
So is there anything in writing? You were talking about standardizing, and do we have any assisted kind of materials
definitely.
that would?
We have for both multi-county and state agencies a how to amend fact sheet, and we have standard disclosure language on our website for both agencies, as well as an internal checklist that they use to gather information and present information to us.
Thank you.
So I just wanted to thank staff for your work on this. I think this is very well done, and I do like the codification of the preliminary review. That saves both the commission a lot of time and resources, but it also saves these local agencies a lot of time and resources so that they don't have to redo things on their end. So well done.
Commissioner Wasserman?
I just wanted to jump in and use a different phrase, but the same thought, which is this is really part of the unsung work of the agency, because we see it at the end of a executive report saying these things were done, and you look at that and you go, wow, that's a sentence this long, but wow, it must have taken a lot of work. And in particular, when you're talking about dealing with staff turnover in other agencies or multi-county agencies, in essence, it's like our staff really need to know that entity about as well as the next new person coming in who hasn't looked broadly at their entire agency to start figuring out, well, is this job title and description fit something that then should fall under a vision, if they have a vision of what a conflict of interest should look like, the code-wise. So I just wanted to chime in again that I really appreciate this kind of work.
Okay, is there any public comment on item 29? What? Okay. Okay, is there a motion?
I move approval as amended.
Second.
Commissioner Adaro,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, thank you. Okay, next is item 30, the legislative report from Phil Ung, our Legislative and External Affairs Director. And the report is set up highlighting two bills, which I'd like to talk about each of those. One has a recommendation, and then we can open up the discussion to the additional ones. So, Phil, starting with the SB 1349 Cal Access, you do have a recommendation on this. If you can give us a little bit of an update, because I believe there's been a vote since you made your report.
Yes, thank you, Madam Chair. Philip Ung, Legislative Director for the record. SB 1349 does set a due date for when the Secretary of State would need to complete a Cal Access system, as well as very specific features that the system should have on launch. We've been working very closely with the stakeholders and the author on this, and that's why we're comfortable giving a support. The bill was approved in Elections Committee. It is now in Senate Appropriations, and I believe it was approved on a bipartisan basis in Elections Committee.
Are there any questions from the commissioners regarding SB 1349? Commissioner Wynn?
Thank you very much, Mr. Ung. So I know that this Cal Access has been kind of plagued with problems right from the beginning. Do you feel like this is a realistic time frame for getting this job done? I mean, we all know that it's an important system to have have in place. It'll help us do our work better. It'll help the Secretary of State do its job better too. But I just wonder about this, just because you say it, don't make it so. And I'm just wondering if that is, if kind of putting a date in law, whether that, is
with
just
an
won't do
option for an
anything.
extension. It does have an immediate built-in option.
Okay. Okay.
To answer the question, Commissioner Nguyen, whenever you're talking about tech systems with the state,
Right.
deadlines are mysterious in
Mhm.
general. It's the word I'll use. And so we think there's a number of factors that go into whether or not the system could be built in that timeline, including the procurement process, or whether or not that procurement process is waived,
Mhm.
which the bill proposes to do, whether or not the legislature allocates enough funds
Mhm.
for the system to go into place, as well as the implementation in general and whatever tech issues may occur.
And I know Chris Reynolds is here, and maybe he could speak to the status, because I know that he has already started the process for the Secretary of State's office and finished the stage 1, maybe stage 2 business analysis plan. Chris Reynolds.
Chris Reynolds with the Secretary of State's office. I'm the chief of the political reform division there. As the chair made mention, we are in the traditional process, which is a new process for getting approval for a technology project. It's a stage gate process. We've cleared the first hurdle. We've received approval on the stage 1 business analysis, and the next stage is the stage 2 alternatives analysis, and then there are 2 more stages after that. So with respect to the waiver of the procurement process, I don't know that that's exactly accurate. What the bill provides for is a waiver from the oversight by control agencies, both the Department of Technology and the Department of Finance. So the bill provides that review, that stage gate process, would not be in place, if you will. But under an analogous situation where an agency is delegated authority for a project, the state administrative manual says there's every expectation that a state agency is going to follow those practices and procedures that are consistent with good project management. So you do shave some time, the approval process, but you still want to undertake all those things that are necessary that take time to make sure you're doing good project management, creating project charters and plans for issue mitigation and so on and so forth. The bill also has some provisions in it for a public hearing that has to take place by a date certain. In its current form, I believe it has a report, or under certain circumstances, reports to the Senate and Assembly elections committees. So there are processes and procedures that will need to be undertaken both on the project management side and on the public input side. And appropriately, the bill talks about consulting with and working with the Fair Political Practices Commission, which is something we're engaged in now. We need to understand what functionality the system should have to make your lives better, if you will, to enable you to do your jobs more effectively and efficiently. So we're undertaking all those things, and those things do take time. When it comes to the procurement process, I would say that what it does, it doesn't really touch the procurement process. It depends on what kind of a procurement you want to do, but that process is very long in and of itself. It involves creating a description of the project, the business requirements, the functionality the system should have, some of which is contained in the bill, some of which will be gathered through the public input process, and some of which will be gathered from talking with agencies like the Fair Political Practices Commission. So that in and of itself is a long process.
Let me jump in and kind of cut to the chase here. So as to
Sure.
Commissioner Nguyen's question, this only requires a report in 20 months and then a goal of implementation in almost 3 years. I'm not an IT expert, but that seems pretty doable to me.
That, from our perspective at this point, I don't want to speak for the agency because the bill is a work in progress, but as the chair indicates, that does not seem unreasonable. And in particular, one of the beneficial features of the due date, if you will, the implementation, is that it occurs at the beginning of an off year. So you do not want, as a matter of planning for the project, to implement it when an election cycle is beginning. So, election year is beginning.
If I
Thank
could
you,
just
Ms.
add
Renz.
one thing too, just to follow up with what Chris was saying, we are actively in the process of working with the Secretary of State, not only on the language of this bill, but also in developing the business requirements concurrently with the bill going through. So Dave Porter, who's our Chief Information Officer, is coordinating with all of our program staff to detail what requirements we would need to see from the new system to help our enforcement division and all of our other divisions as well, in terms of not only sort of identifying what the issues are with the current system, but thinking hopefully broader than that and what can the new system add to our mission. So that path, we're on that path at the same time that the bill is going through as well.
Any other questions from the commissioners? Okay, is there any public comment on SB 1349?
Hi, Chair Remke, members of the commission, Nicholas Heidorn with California Common Cause. Just very briefly, we think this is going to make for a more reliable Cal access. We think it's going to improve transparency for the public. We think it's going to make it easier for filers to actually go about doing the filing business. So we think this is a triple win. We think it's necessary, and we think the time is right. So we'd urge support. Thank you.
Can I just ask a quick question on that? We think it's necessary. I think that question keeps floating around out there. Is the bill necessary to start a new Cal access?
I think there are mixed opinions on it. You could potentially just do it with the budget allocation. We think having a bill helps draw attention to it and puts in some requirements that we think are important, like allowing filing to be done electronically and having a data-driven process.
Okay, thank you. Is there a motion on the recommendation?
Madam Chair, I just wanted to make one statement, was that I actually had the opportunity to hear Secretary Padilla speak a little bit about this bill in San Diego on Monday. And it's very heartening that that Mr. Reynolds and Secretary Padilla really have this cooperative view about how this needs to get done. I just wanted to make that not that he didn't really need to persuade me, because I think I was already there, but I just wanted to say that it was helpful, and it was also a way for the public to hear about these things from the different channels of how we're trying to get there. So, thank you.
Is there a motion on the recommendation?
So I move approval of the staff recommendation.
And I'll second.
Commissioner Adaro,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, and then the next bill that is highlighted for discussion, if there are any questions or comments regarding Phil's report on AB 2523, the contribution limits local elections bill. Any questions or comments on that? I appreciate the highlights to the concerns that you have brought out, Phil. I think there are some definite, let me start by saying that I support local contribution limits. I have concerns about the implementation of this bill as currently drafted. I think the most significant concern I have is that it's not in the Political Reform Act. So we are going down a path of really creating two processes here that obviously overlap in almost every way, but without giving us the oversight and, most importantly, any enforcement efforts on this. I'm sure that there are reasons and explanations for that, but I am not convinced that it's the right approach. I think the implementation issues are, like I said, enforcement, so we wouldn't have that authority, and even if we couldn't take it or didn't want to accept it, I think having it in the act would be more understandable for all local jurisdictions, because as you know, everything regarding local jurisdictions as far as reporting is in the act. I mean, the terms and conditions regarding what a contribution is, what an expenditure is in the act. And as we also know, when limits are imposed, we often see an incredible increase in independent expenditures. Unfortunately, sometimes along with that, laundered campaign contributions, all things that we as the commission would continue to be required to oversee, even though we are creating this separate system in the elections code, which just it doesn't make logical sense to me. So I hope that that continues to be discussed as this bill goes through the process, and that Phil expresses our concerns with this approach.
We wanted to make sure that we highlighted this bill in this month's agenda because Commissioner Wasserman brought it up when it was just a spot bill in March, and it now has language. We decided on a monitor because there's a lot of activity and a lot of local associations who were involved in discussions and asking for amendments. So the bill is somewhat still being formed, and so we'll continue to watch it as it matures, and happy to bring it back to you if we feel like it gets to a point and our concerns are not yet addressed.
Commissioner Wynn?
Thank you, Phil.
Mm-hmm.
So I noticed that it was set for hearing earlier last week. Did it have a hearing?
It did, yes. And it was approved in Elections Committee, I believe, on partisan grounds.
And so did you have an opportunity to go? I mean, were these issues that you have raised here, were they raised by you or somebody else at the hearing?
Right. I was not, I did not testify,
Okay.
but they were raised in the committee analysis.
Okay.
And so the assembly members were aware of
Good.
the issue.
Okay. Thank you.
And I think the goal of highlighting is to give Phil that comfort level, expressing these concerns and trying to shape this into something that we could, ideally support if we could get it into the act and have some more understanding of the scope of it. That would obviously be our preference. Commissioner Kesher?
I just had a question. So currently, as worded, the bill provides that local agencies, if they adopt a contribution limit, then they also then have to do enforcement locally of that contribution limit. Is that correct?
That they may adopt enforcement.
Okay.
That's one of the issues that we're monitoring closely because I think even the local associations are unaware of how that would take place.
Mm-hmm.
I know the League of Cities is wondering if their city attorney can do it. There's some
Right.
conflict issues there because city attorneys are elected officials,
Mm-hmm.
and or whether or not they need to hire outside counsel. I know there's been discussions with the DAs about whether or not the DAs would prioritize this issue among all the other issues that they have on their docket, and whether or not if DAs are cherry picking these things, whether or not that is a disincentive.
Right.
Generally, I know there's also been discussions of having the commission be alternative enforcement to district attorneys, which I also don't think is ideal that we're the bench for the DAs versus the active enforcement agency.
That's kind of where I was going with it, because it seems to me that there's a lot of local agencies who may not have the resources to create an enforcement division for this type of issue. And so if it's a may, and they may create this, if they choose not to, then who would be enforcing these campaign contribution limits?
I believe it's the district attorneys. I
Who
think it
may
would default.
enforce it.
Who
It's not a
again would have
mandate.
filing discretion.
Okay, thanks.
Commissioner Wasserman?
Thank you for this report and this monitoring. Yeah, as I may have mentioned last time, I don't recall, watching, for example, a small city try to figure out if they're going to have contribution limits, and then wrangle through the what are the unintended consequences if someone is focusing only on attempting to limit contributions. What the chair mentioned about independent expenditures and about money laundering, all the discussions about the resources, who's going to do what standards are going to be in play. It's interesting because after the last meeting, I made a few phone calls to folks to sort of like when we try to sort of drum up bodies, they say, hey, there's this thing coming up. What if you want to have input, give us input. And it seemed to me, the impression I got was, oh, well, if we have a contribution limit already, then we don't care what this does. And then if we don't have a contribution limit, why is someone else coming and telling our local community how we should do this? What has changed? And I think both of those are really focusing on one aspect of the debates and the issues, when there are so many, like we said, unintended consequences, complexities, and enforcement being a huge one. And what the chair said about where this goes in the code, it's sort of, that's disturbing as well. Just why, if this is supposed to be there in the political format, what we do, why is it over there? It's just going to add one more layer of confusion. So I want to thank you all for following up on this.
Any other questions? Is there any public comment on this bill? Again, we're not taking a formal vote, but we are having a discussion, so we'll open it up.
Hi, Chair Remke, members of the committee. Nicholas Heidorn with California Common Cause. Common Cause is in strong support of AB 2523, so I wanted to be here to talk a little bit about why we support it and also talk about some of the concerns raised in the staff report.
Are you the sponsors of the
We are
bill?
not the sponsors. We are supporters of the bill.
Okay.
Okay. As has been mentioned, AB 2523 would establish a $4,200 cap on local contributions, but only in those jurisdictions that do not adopt contribution limits themselves. So in terms of background for the need of the bill, Common Cause decided to do a survey of all cities and counties to determine how many had actually adopted contribution limits. What we found is 23% of cities have adopted contribution limits and 28% of counties, meaning that the vast majority of local jurisdictions have no limits whatsoever. In those jurisdictions, literally any amount can be given, including donations that exceed the average salary of the average Californian in a year. And in fact, when California Common Cause looked into this, we found very large contributions. We found numerous examples of people giving $20,000 direct contributions, $50,000 direct contributions, $90,000+ direct contributions to candidates.
I know you point out a few examples and you have a fact sheet regarding that, but other than those few examples, I mean, when you're saying these numbers, are you saying in the 60% of cities that don't have contribution limits, this is a prevalent activity of $20,000, $30,000, $90,000 contributions, or is these kind of the one-offs in certain locations you found?
Most candidates are not receiving contributions of this level, but what I will say is every single jurisdiction that I looked at that did not have limits, I found examples of contributions exceeding the state limits. So I wouldn't say this is unusual, but I wouldn't say it's the average candidate either.
But under the bill as amended more recently, a local jurisdiction, it's not a cap anymore. When the bill first was introduced, and I think that was the driving notion behind it, was that we don't want these large contributions that could be improper influence. So there was a cap at the 4,200. But I think to alleviate some perhaps opposition, it's been changed to a local can adopt any amount. It could be higher or lower than the state. So we could have, like Alameda already does have, $20,000 contribution limits.
Yes, that's correct. I mean, one of the things I'd point out, Commissioner Wasserman was talking about how at the last meeting, how this has traditionally been an aspect of local control. Part of what we want to do with this bill is stop the worst abuses, but otherwise try and incentivize locals to really look at this issue for themselves. So for many jurisdictions, simply by inertia, this cap will go into effect, and the vast majority of jurisdictions will have what is actually a fairly generous upper cap. But for those jurisdictions that find it problematic, they can then have a discussion in their community. What this bill does is it drives that discussion. So the way we would perceive it is the default in California currently is there are no limits. We would like to shift the default to be a $4,200 limit pegged to the state. And then if locals feel for whatever reason, perhaps concerns over IEs, they want to have higher amounts, let's at least have that discussion in that community as opposed to having the default be anything goes.
But right now they can have that discussion if they think there's a problem in their local jurisdiction. And right now they can impose their limits as they think are appropriate.
That's true, of course, but inertia being that's what it is. Many jurisdictions simply won't have that discussion. There's potentially incentives by certain members who may have received high contributions to not have that discussion. We talked with one member from a jurisdiction that had no limits who said she was very interested in what we were doing because she thought it was a problem in her jurisdiction, but didn't want to personally bring it up. My sense was for fear of offending fellow members of the council who may have received high contributions.
Any other comments, Commissioner?
Yeah, I'd love to just ask you a question about enforcement. So the way the enforcement piece is in the bill, and I don't have the bill in front of me, so I'm relying on Mr. Ung's,
Yes.
write-up. But this, having it be kind of discretionary at the local level, with a DA who is also an elected official and, probably has friends at the local level, running for office too. It just seems like that's a very problematic piece of this legislation.
So one of the things that we wanted to do with this legislation is try and stay consistent to what's currently happening at the local level. The vast majority of the 100+ jurisdictions that have adopted limits use DA enforcement. So we want to stay consistent with what's current practice.
Because I think, though, the issue would be that they've decided that works for them. They've had a commitment from the district attorney's office, some reason that that's been the chosen method. I guess, again, the concern is this is just a may with no. Let me actually ask it more directly. Have you talked to the District Attorneys Association, and do they have a position on this bill?
The author's office has talked to the District Attorneys Association. I have not. My understanding is, well, they are clearly neutral at this point because we've not received any opposition from them.
Have they raised any concerns that you're aware of?
The one concern that I'm aware of is because district attorneys are elected, they wondered about what should be done if a district attorney has a contribution over the limit. Would that create a conflict? And we are working with them at looking at alternatives. One alternative might be to refer the matter to a sister DA from a neighboring county to have them look at the issue instead. But we're continuing to work with them, and I think we will find a solution to that works for everyone.
But they haven't raised any concerns regarding their resource allocation for this versus crimes they have to pursue.
I believe they're looking at it at the moment, but I haven't heard any specific concerns. Again, I have not had direct communication with the DAs, though.
Okay, and then just my final question is what response you would have to the concerns about this not being in the Political Reform Act, which it seems very logical for many of us that it would be in the Political Reform Act.
All right, I appreciate the question. It is correct that it's not in the Political Reform Act. At this point, we think that's appropriate, but the bill continues to move and could be amended to potentially look at that. As staff correctly notes, the Political Reform Act is actually expressly clear that the legislature is not restricted from continuing to impose requirements outside the Political Reform Act. And in fact, what this bill does, AB 2523, it amends the election code, the same exact provision where local contribution limits are currently provided for. So we're
just
we're
the
actually
authority to adopt it. It's like a one line for each city, county, or special district. You can. But there's also provisions in the Political Reform Act which says nothing in the act nullifies any local jurisdiction's contribution limits. And then much, obviously, more that we've already talked about.
Sure. I mean, we understand why you might have a preference of putting it in the PRA. We don't think, though, that there's any requirement that it be in the PRA. There's certainly examples of other campaign elements.
Well, why do you
that are
have
covered.
a preference that it's not in the PRA? Let's ask that question.
Well, I think there are a number of considerations. One of them certainly is we're simply amending the same aspect of where it's already been. I think it would also be a little unusual to amend the PRA and put in a provision that the FPPC wouldn't be enforcing. So that would be somewhat of an unusual amendment to the PRA, we feel.
Unless, of course, it had us have enforcement powers, or at least the ability to contract with locals to enforce. But I guess we'll continue to have these discussions as you move through and address other concerns, and then we'll bring it back if it continues in its current form, and we can discuss it further unless there are any other questions from the commissioners.
If I may just
Sure.
briefly, there are two things that I just wanted to highlight. And one is when you're pushing the default, you're moving sort of opt-in, opt-ins versus opt-outs. And that's completely a game changer because we know folks, if you have to affirmatively do something, we talked about inertia, you are changing it. It's just done. And the second thing is I don't think as a practical matter, many jurisdictions will say, well, now that we didn't have any before, we'll go back because there's this cap and put something higher. I don't see that as something that someone is going to champion, even under the rubric of saying free speech or whatnot. So practically, there's that. There's actually a third unintended consequence, which I think about in terms of jurisdictions that are used to low dollar elections. And in there, they tend to function more on social norm than, I sound like one of my professors, a social norm, rather than the actual, any sort of law. So in a smaller jurisdiction, if someone gives $100, oh my gosh, that's a huge thing. 250, they've just bought the candidate in the view of the public. And then suddenly now we sort of have a law which is maybe designed around, as you said, there's certain components you've been looking at, certain segments of the political system, certain entities and the way they've run, that then sets a new bar based kind of on those. And suddenly, hey, you've introduced more money into the process, potentially. Just a thought.
Yeah, I think it's important to know whenever you do a policy, there are going to be some changes in terms of how people react to it. I would say with your last example, the social norms example, if suddenly you do have a community that was used to really small contributions and then someone decides, hey, I'm going to go all the way up to the new limit, it could well be that that community will decide, whoa, this is against the social norms of our community, and this bill still enables them to enact lower limits. So we still think it's a discussion worth having, and we think the balancing factor is looking at those communities where they are getting $90,000 contributions.
And one of your other concerns was the incentivizing, because if there are elected officials who are reform-minded but don't want to see themselves eliminated on this basis, or make themselves ineffectual in terms of votes for other things that are important to their constituency, that this would give them it would go in the direction that actually you're saying that might actually be out there. That there may be folks who are saying this is the way we need to go, just we lack the political will, and incumbents may be incentivized not to make such changes.
It's true. One of the things that we actually hope for with this bill is, if a conversation does happen, perhaps in a community where one member thinks the limit should be higher, it could lead to re-examination where the community comes together and says, actually, we think 4,200 is too high and we want to go the other direction. So we actually do think the conversation piece is one of the important elements of this bill.
Right. Because, again, as a practical matter, you're more likely to have folks saying, we want to be tougher.
From Common Cause's perspective, that would be wonderful.
Okay, thank you.
Thank you.
Any other public comment on this issue? All right, well, there's no recommendation right now. That doesn't stop a commissioner from making a recommendation, but or we could just bring it back and discuss it further. Hopefully, our issues can be addressed. If they're not, I would expect a different recommendation in the future. Okay, commissioners, any other questions regarding any of the other bills in the report?
I have one question.
Okay, Commissioner Nguyen.
So, Mr. Ung, thank you very much. I had a question about AB 700. So we haven't opposed unless amended on that bill. And my understanding was that you met with the author's office fairly recently. And I'm just wondering, how did that conversation go? And does there seem to be a willingness to address some of the concerns that we have?
Right. Well, we actually have not met with the author's office recently. What we have done is developed our suggested amendments and shared that with the author and the sponsor. I have met with the sponsor and discussed the amendments, and they said they're discussing that with their attorneys and trying to see what is possible. They tell us that the current draft of the bill was put together through a lot of negotiation with a coalition of stakeholders, and that our amendments could break that. And so they are worried about what happens if they take our amendments. I informed them that we weren't part of that coalition and we're opposed. So we're happy to have them take our amendments as soon as possible. Mm-hmm.
Any other questions or comments? Okay, the report will be submitted. Thank you. And then we have the executive staff reports, which I would just like to point out a couple highlights of the report. Enforcement Division's ability to be moving through those cases in a swift and effective manner, and a low number of 499 pending cases. So that number continues to go down despite the continued, it's always a moving cycle of new ones coming in and trying to resolve those, but they continue to lower the pending case, which is great. And thank you, Galena, for your hard work on that. Obviously, everyone's doing a lot of hard work, as this report shows. I also just wanted to comment real quickly regarding upcoming regulations. This is in the legal report, page 9. As you can see, believe it or not, there are none planned for the next 2 months, and that's for a couple of reasons. Number one, as you probably have heard, we are not having a June meeting, and that is for two main reasons. Number one, obviously the primary, and we want to be able to have all resources available to provide adequate advice, and if necessary, have the enforcement geared towards that. The second issue is because that's when we think we will be deep in the rewrite process of the act. We're going to be getting it back from the students We think mid-May, we hope, internally reviewing it extensively, and then spending the next 4 or 5 months with a very hard-hitting outreach program to get as many comments as we can. We're talking about having smaller meeting groups with people really just hashing out discussions about concerns and issues, having it on our website. So again, that's going to be like a 4 or 5 month process, trying to solicit as much input as we can. So anyhow, that is why there are no regulations, because there's a lot of other work. But come July, I think we're going to start up again, and we'll have some interesting regulations to share then. Yeah.
Thanks so much, Jody, for that, explanation of kind of the timing on major projects. When you are, working hard to get input, are you going to try and move around the state a little bit? I mean, I know there are a lot of political attorneys here, and, it feels like this is really where our work is. But, we do know that local, governments and lots of different commissions are around the state. And so, much like the league comes to our meetings, it would be nice maybe to go out and solicit input.
Yeah, we're in the process right now of working with California Forward, who's our partner on the project, to develop the specifics of the outreach plan. But we are looking at things like that, and as well as doing some sort of, even if it's not physically on site somewhere else, but webinars.
Super.
Or soliciting comments online, things like that, so we can accommodate people who are not geographically in Sacramento.
Well, it's one thing to sit and read regulations, but when you hear a conversation, it would kind of spark, and there are a lot of people in a lot of different parts of the state. So I would love to see the webinars rather than online communication where people just sitting.
I think it's all of the above.
Good.
In-person, webinars, online. They have a pretty robust idea, and Phil's kind of our project manager, if you want to add anything to that.
No, I think that's absolutely right. California Forward is really approaching it from a real comprehensive standpoint of what's the best way to get in touch with people and get them involved in this process.
And once we have it finalized, obviously we're happy to share that plan with you. We have a draft, but we're working on through it.
Just a quick question. Are we anticipating with this extended outreach, is this the first time we've done this kind of extended outreach where we're going to be receiving comments online, et cetera? And do we have the resources to handle whatever increase?
That's why we're so lucky to be working with California Forward, because they're going to really take
that on.
Yeah, the heavy lifting on that. And that's why, despite not loving online interaction, it's a way to kind of have it more organized, and we can be more responsive to all the comments, because it's hard to just sit in a meeting and hear a lot of people talk. We really want to see some written work and or comments about actual suggestions.
And we definitely see our role as the commission staff as providing the subject matter expertise. And so we're looking forward to working with them to help us, because they have implemented these types of projects in the past, to give us suggestions on best practices so that it is we want it to be workable, and obviously to inform a good product at the end of it. So.
And we have connected with all of the local ethics commissions and informed them of our timeline. And so they are aware of it and are happy to participate when it comes around.
Any other?
I just had a brief unrelated comment. I wanted to, this relates to the legal division report, but I wanted to thank Trish Mayer for presenting in Union City. She did a candidates and treasurer workshop out there. So it was great to see Trish and John attended as well. And I think Tara. So it was great. I'm sorry, Deborah. Yes, it was great to see commission staff outside of the friendly confines of the commission offices here in Alameda County, and it was the presentation was very well received. It was very well done. The candidates who attended got a lot of very useful information. So thanks for taking the time to do that.
Okay.
I had
Commissioner.
two things I wanted to say. I wanted to thank staff for a lot of assistance and support I received in outreach and a training that I was involved with. I did go, as I said earlier, on Monday, I was in San Diego for the Money and Politics Forum that was sponsored by the San Diego Ethics Commission, along with the University of San Diego Law School and the San Diego Bar Association. And I got to see some of our alums, our former chair, Ann Ravel, and our former head of enforcement, Gary Winnick, were there. And it was, and of course, the Secretary of State. And it was very interesting to go also then meet the ethics commissioners and talk to them. And also, it was a really good sense of how our communications to them are reflected, because they are aware of what we're doing They're excited about many of the things we're working on. People were talking about, the comprehensive look at the act, and it was a really well attended event. It was a great venue at the top of I think it was the 9th floor of this amazing civic sort of treasure of a library. But I appreciate the help there, especially then the help for the Cause Political Institute that I spoke at in end of March, which was jointly with USC and is set up by another alum, former chair Dan Schnurr. And Ms. Mayer and Ms. West provided me with various materials, including sort of, I think it was your top 6 things for local accounts. And I got to speak with a lot of very, very engaged community leaders and future community leaders, because it's a pipeline for community leadership kind of program with this 501c3. And it was interesting how much they wanted to know and how much they wanted to take back to the agencies or entities or communities. I mean, I was scheduled to talk to them for an hour, and they asked so many questions. It was almost 2 hours, which is probably not surprising given the amount that I talked. But believe me, this was them asking me questions and me attempting to respond. But in addition to having several years now on the commission, I had a lot of really good support from the staff, and I really appreciated all the materials, sort of focus things down. And one of the things I used for these folks was our local candidate and treasurer video. I said, before you show up to this sort of roundtable setting, you really need to have done that. And I told them it was a great video. It's only 34 minutes, and it covered a lot of things. And they did watch it, and they did ask questions. It's particularly interesting questions about the money laundering section, about how do they identify and avoid those situations for the future. And I thought those were really good. So thank you.
Okay, if there are no other questions or comments regarding the staff reports, those will be submitted, and then I would move to adjourn the meeting.
Second.
Commissioner Adaro?
Yes.
Commissioner Kasher?
Yes.
Commissioner Wasserman?
Yes.
Commissioner Wynn?
Yes.
Chair Remke?
Yes.
This motion passes.
Thank you.